What happens when the parties reach an agreement?
Yes, well, hopefully this is going to be the outcome of a successful mediation. It essentially depends on their needs and their circumstances. So if a couple has been married, they will be looking for a legal separation or a divorce, one would imagine. And that is where the jurisdictional differences come in. In Ireland, for example, a couple might require a contract of separation. They might require a legal separation, or they might require an order for divorce, the latter two of which will both require some input from the court. If the parties aren't married, they might require a court order of some kind, or a contract or an agreement might suffice. So the mediator must be aware of the various different options for formalising the agreement that are there, and then will need to liaise with the parties' legal advisors or facilitate the parties themselves in bringing the mediated agreement to their legal advisors. But the first thing that the mediator will do will be helping the parties craft and draft their mediated agreement, mediated settlement agreement, memorandum of understanding. And this document will often be broader than the final legal agreement, because it might include things that maybe don't have a legally enforceable outcome, such as, we will agree to be respectful of each other, to give each other personal space. We agree that neither of us will speak badly about the other party to the children. All of those slightly softer, if you like, but vitally important agreements that wouldn't necessarily form part of a legal agreement. So if a court input is required, what will often happen is that the legal advisors will draw up the relevant documentation, and the parties might just have to attend in court very briefly to confirm to the judge that they have in fact reached an agreement through mediation and they are happy for it to be made a rule of court. Oftentimes as well, because family mediation really looks at the future of a family that is going to change over time, where the parties' needs, the children's needs will change over time. Often parties will also agree to return to mediation if new issues arise that they can't manage themselves, or might even build in a review date, say, in their mediated agreement to review circumstances in 6 months, in a year, when a child begins school, when a child finishes school and moves on to third level, something like that. And that, to be honest, is really always a kind of a sign of success for us as mediators, where parties have realised that this is actually a way of managing their very difficult decisions into the future, and that it has worked, and they're agreeing to negotiate future arrangements rather than saying, well, if it all falls apart, we'll go to court, or if circumstances change, we'll go to court.